Washington, D.C. 95.9 W240DJ, WMMJ HD3, WDCJ-FM HD3, and worldwide at WOLDCnews.com.
The views and opinions expressed in this program are those of the host and guests and do not necessarily reflect the views of Urban One Incorporated, Radio One, or any of its subsidiary companies.
The following program is paid for by Barbara Arnwine.
The views and opinions expressed in this program are those of the host and guests and do not necessarily reflect the views of Urban One Incorporated, Radio One, or any of its subsidiary companies.
It's time now for Igniting Change, a weekly provocative and empowering program where you, the listener, can ignite change. Now here's your host, Barbara Arnwine.
Get up, stand up. Stand up for your rights.
Everyone, welcome to Igniting Change. You know we got a great show for you today. Oh, Daryl Jones and I have been on the radio show circuit all morning long, bringing good news to people because we are rallying tomorrow. And we're going to talk more about that. Yes, we're going to rally at the Supreme Court tomorrow, and you want to be there, and you want to join us. We're going to talk about that. We're going to talk about some other things going on in our country, but we're going to look a lot at this court and what's going on with this court and its many problems and why you need to know and why you need to be involved because it affects your life, and you're going to find out more about that. But let me bring up my mighty co-host. Woo! He's a powerful leader. He has, done some amazing, just fabulous, difference-making work in our nation for years and years, and now we are about to turn it out this week, and he's going to tell you about all of what's coming up. You know I'm talking about none other than the leader of the board of the Transformative Justice Coalition, one Daryl D. Jones. Hey, Daryl.
Hey, Barbara, it must be Tuesday, it must be noon Eastern Standard Time, because we're talking igniting change. My goodness, Barbara, my goodness. I always say week by week seems like much too long for us to be on the air because so much transpires. Tomorrow, at this U.S. Supreme Court, we'll be there on the front steps at the front of the building, there, rallying, protesting, pushing, hoping that the justices there do the right thing in the case we call the Louisiana versus Callais case. We're going to talk a lot about that today. But, Barbara, my goodness, we really need people to show out for tomorrow, to come out, whether you're in the DMV, right, the District of Columbia, Maryland, and Virginia. Come on over to the Supreme Court of the United States. If you're in Baton Rouge, Louisiana, you can show up at the Louisiana State House to protest this Callais case that's has the potential to change the whole framework of voting in districts and what electoral maps could look like throughout the United States, Barbara. This is a huge case, one of the biggest cases, I think, in dealing with voting rights of our lifetime.
And once again, black political power is in the bull's eye of the court. People are trying to destroy African-American political power, and we're going to be talking about that. But also, we just want to inform you what's going on generally with the court. So we are so glad that we have, as our first guest today, one of the nation's foremost experts on the Supreme Court. He has been just an amazing thought leader. He has helped to expose misdeeds where people have tried to engage in major political corruption around the court. But he's also been a speaker towards what are the high ideals that this court should always live up to. I am so happy to introduce as our first guest. He is an author and political commentator, executive director of Court Accountability, former chief counsel for U.S. Senator Sheldon Whitehouse, former staff for the Senate Judiciary Committee, Federal Courts Oversight, Agency Action, and Federal Rights Subcommittee. He was a former attorney for the U.S. Department of Justice and a former associate at Covington and Burling law firm. I am talking about none other and want to welcome to our show Alex Aronson. Hi, Alex.
Barbara, Daryl, it is wonderful to be back with you. So it's always such an honor to be here with you, igniting change.
My. Woo! You know, last time we talked to you that we were blessed to have you on the show was in June of 2024. Can you believe that? July of 2024, right? And we were talking about, you know, that prior Supreme Court term and U.S. versus Trump and a whole lot of other stuff. But it is just, you know, so imperative that we keep our eyes on this court. And we wanted to talk to you because you are one of the most informed persons in this country about what's going on at this court. So we wanted to see if you could tell us, as you look at the many developments that have transpired in this Trump year of the court of 2025, what are the trend lines that our audience needs to be most aware of at the court?
Yeah, of course. And it's been such a dizzying year at the courts in general, where we've seen this incredible resistance emerge in these first now 10 months or so of the Trump administration, with this incredible array of public interest litigation working to stop in the lower courts this unconstitutional affront to our people, happening across so many different vectors of the Trump administration's Project 2025 agenda. And what's been striking, Barbara, is that in the lower courts we've seen a resolute determination from lower court judges appointed by presidents of both political parties, Reagan judges, Bush judges, Obama, Biden, Clinton, the like, stopping these unconstitutional policies. We've recently tabulated the win rates of plaintiffs challenging Trump's policies, and something like 60% of plaintiffs challenging these unconstitutional policies are winning in lower courts. And a lot of those wins are holding in the appeals courts as the appeals, resolve the appeals from those challenges. But what we've noticed and just started seeing, particularly over the course of the summer, is that when these cases, and not all of them do get to the Supreme Court, but when they do get to the Supreme Court, the Roberts majority, time and time again, has been there for Trump's agenda, using its shadow docket, where it's not even explaining itself, to effectively greenlight this assault on our people and on our Constitution. And so we find ourselves, as this new term starts, and as this critical Callais case implicating the future of the Voting Rights Act is heard for argument tomorrow, these questions about whether this court is at all a bulwark against an autocratic fascist president, or whether it is better understood at this point as part of that threat directly.
Wow. Daryl?
And Alex, if people are looking at this court, one of the things that's really interesting is that, this Supreme Court is considered to have like the lowest approval rating of any Supreme Court ever. I mean, how do you explain that, Alex? And the cases that they're now getting ready to deal with, getting ready to handle, how could that impact this?
Yeah, I mean, it's really heart-wrenching to actually see the extent to which public faith in the Supreme Court has dropped, and so precipitously. But it's also understandable, and I share that plummeting lack in faith in these justices to actually do their jobs, to apply law to fact and to be impartial jurists. I think everything we've seen from the majority justices in particular has belied that, that ideal of what we should expect in our judges.
from the record of corruption and engagement with billionaires who have interests before the court, undisclosed financial entanglements, upwards of millions of dollars in undisclosed gifts, the stories of Clarence Thomas's RVs and all of the free trips and things he took over the course of years that he never disclosed. Very serious questions about whether he violated tax laws doing so, and whether the billionaire Harlan Crow that was funding his corruption did that. Barbara, when we spoke last year, we saw photographic evidence that Sam Alito was flying the banner of the MAGA insurrection outside his home while he was sitting on the case to determine whether Trump should be immune from accountability for that very insurrection. And so, in case after case, what we're seeing is a majority that is not committed to law, not committed to justice or to principles of equality under law, but is interested in accruing power to itself, in advancing the political and financial interests of its ideological and political allies, and ultimately in dismantling the project of American democracy. And at this point, I think it's as sad as it is, it's important that people see with clear eyes what this court has become in the hands of John Roberts. And I think, we need to have a conversation about John Roberts, the Chief Justice, when we talk about this, right? Because he knew what Trump was. We could see it in the year-end report that he issued at the end of the year, that he saw Trump was going to steamroll and defy the Supreme Court's rulings. And so here we have a Chief Justice who knew what he was signing up for and barreled full steam ahead to hand the country this situation nevertheless. And I think in tomorrow's case, in this case on the Voting Rights Act and Section 2, and whether we will still be able to have any enforcement at all of the Voting Rights Act to remedy our nation's history of discrimination against black and communities of color, is the completion now of John Roberts' career-long project to eviscerate that signature accomplishment of the 20th century. And so here we are, where John Roberts, again, I think finds himself at a crossroads between further advancement and completion of a project that he has been committed to for his life, reducing and diminishing black voting power through basically systematically taking out the Voting Rights Act, or having any semblance of a democracy to lay claim to when his legacy is written at the end of this.
Wow. We've been telling people all day, all week, all month, all year long that this Callais case is the most important case on voting rights and racial justice since Brown v. Board, in our opinion. And mainly because of what happened in 2013 in the Shelby versus Holder case, where they really destroyed the enforcement power of Section 5, and now they're going after Section 2. Remember that in Holder, in Shelby versus Holder, Chief Justice Roberts said there's always Section 2 for actual proven, quote, discrimination, that there's Section 2, and that our ruling today does not, really harm the act. I think the question, Alex, is that as we sit here, as we look at this, we need the average American to build into your consciousness a determination to watch what the court is doing with our voting rights and with our constitutional protections. Talk about some of the things that this court has done that has been shocking regarding our constitutional protections.
Yeah. I mean, where do you even start, Barbara? But I think the way you described what they did in the Shelby case, the way you described what they did in the Shelby case is such a great example of the way they manipulate the law to incrementally advance their political aims, right? As you described, they took out Section 4 and 5, the all-important preclearance provisions of the Voting Rights Act, through which the Justice Department had an independent role in monitoring these jurisdictions that had a history of racial discrimination in voting. And they took that out by creating this invented principle called the equal state sovereignty principle. Of course, that was John Roberts. This idea has no basis in the text or original history of the Constitution. They just made it up to justify their goal of taking out voting rights section 2 or 4 and 5, the preclearance provisions. And as you noted, they said, of course, you still have this